Hello everybody, welcome to the National Paralegal College Faculty's Legal Analysis of the News. Today is November 27th of the year 2013, and today I want to discuss a very interesting and even overlooked federal court decision that came down this week. You didn't see a lot of media attention to it, but it's a very interesting case with a lot of very powerful ramifications. And that is a decision out of the federal court for the Western District of Wisconsin, a district court, that income tax exclusions for parsonage, which have been part of the Internal Revenue Code for a long time, are unconstitutional. This was based on a lawsuit brought by the Freedom from Religion Foundation, an organization that tries to support the separation of church and state, and indeed that they were successful in this case. The federal district judge ruled that parsonage, which we'll discuss what that is in a moment, cannot be excluded from income tax by the Internal Revenue Code. Now, as you can see from this headline, the general idea of parsonage, which is something that's been going on probably for centuries and centuries, is that clergy members are often given the benefit of either housing in church property or in religious property, or given payments for their rent in their off-site housing. Now, of course, there's nothing inherently wrong with giving clergy members this sort of a benefit. The only issue is whether this sort of a benefit can be excluded from gross income. And as you can see from articles like this, in the last couple of days, people have been asking, essentially, why pastors and why clergy members receive this benefit. And the answer is, the case, this was actually the name of the case, Freedom from Religion Foundation versus Lieu. This is the site of the case. But the answer why this benefit has been received from an income tax perspective is because it appears in the Internal Revenue Code. This is the section from the Internal Revenue Code. It's section 107 of Title 26 of the United States Code, also known as the Internal Revenue Code, and it says as follows: rental value of parsonages. In the case of a minister of the gospel, which will be important later on, gross income does not include the rental value of a home furnished to him as part of his compensation, or the rental allowance paid to him as part of his compensation, etc. What this means is that if the church or if the religious organization gives a clergy member, a religious official, either housing or pays for this clergy member's housing, something generally known as parsonage, that is excluded from gross income. Other types of people who are given housing as part of their compensation, somebody, for example, who is a custodian or a caretaker, if that person is giving housing or rent money, that's considered taxable income, and you have to pay income tax on the fair value of that housing benefit. Section 107 exempts parsonage from income tax if you're talking about a religious official, if you're talking about a member of the clergy. And that's what this case was about, the Freedom of Religion Foundation case, which happened in the Western District of Wisconsin. Now keep in mind, of course, that doesn't mean that it's binding on the whole country. That doesn't mean that starting tomorrow, people are never going to be able to write off parsonage again. This is not the U.S. Supreme Court that made this decision. It's not even a circuit court. Wisconsin is within the Seventh Circuit Court of Appeals, but even other people in the Seventh Circuit don't necessarily have to listen to a district court. A district court decision is only binding on the people who are actually before them, but it's not actually binding on, let's say, other states, other circuits, other districts, the rest of the country. But it is important to look at because I'm sure this is not the last we've heard of this issue. I'm sure this case may very well go up to the Seventh Circuit Court of Appeals, and it may also be brought up in other courts in other circuits. And what I am going to do with you today is I'm going to take you through this court decision and discuss some of the legal issues that were relevant to the decision. One very interesting thing I noticed about this decision in reading it is that the judge actually, before getting to the meat of the decision, discussing the legal issues, actually takes a few paragraphs to justify the decision. The judge was aware that he was deciding something that could have monumental implications, and he felt the need to at least justify himself at the outset. Listen to what the judge says over here. In concluding that this section violates the Constitution, I acknowledge that the benefit of that the exemption provides to many ministers, and the loss that may be felt of the if the exemption is withdrawn. And some might view a rule against preferential treatment as exhibiting hostility towards religion, but equality should never be mistaken for hostility. What the judge is trying to say is, it's not that I'm anti-religion, it's just that I'm trying to enforce the First Amendment to the United States Constitution. And in fact, the judge goes so far as to say the converse. If the statute imposed a tax solely against ministers, or granted an exemption to anyone except for ministers, without a secular reason, that law would also violate the Constitution just as this one does. In other words, the judge is saying, don't take this personal. It's not that I have anything against religion or anything against ministers. It's just that I want everybody to be treated equally. Again, this doesn't really have any legal significance, these few paragraphs. I just thought it was very interesting that the judge felt a little bit of a need for self-justification before launching into this issue. The first issue discussed by the court, really a threshold issue, is the issue of standing. Now, standing is a requirement of every federal case. In order for somebody to bring a case, they can't just have brought the lawsuit because they don't like a law or because they want a change. You have to actually have suffered some sort of an injury. The famous U.S. Supreme Court case with regard to standing in tax cases, such as this one, came from a famous U.S. Supreme Court case in 1984 called Allen v. Wright. What happened in Allen versus Wright is that the IRS essentially had been administering this rule. There's a rule saying that that racially discriminatory organizations were not allowed to get tax-exempt status, and there was a discriminatory school that was getting tax-exempt status, and some parents in the area, parents of minority children, felt that the IRS was not doing a good enough job of enforcing this rule, and so they brought a lawsuit. And in that case, the U.S. Supreme Court actually said that there was no standing, because the parents did not allege an actual injury. It was a 5-4 decision, a very controversial decision, a decision that remains controversial to this day. In that case, the court said that it is entirely speculative whether withdrawal of a particular school's exemption would have had a significant impact on the racial composition of the public schools. Essentially, the parents had made the allegation that by being racially discriminatory, this school is drawing the white children out, leaving the public schools much less diverse. And the Supreme Court essentially said that's speculative, you have no specific reason to allege that, and the minority parents were actually denied standing. So whenever you're challenging a tax law, the first thing you have to worry about is standing. When you actually bring a lawsuit challenging a tax law, can you show that you're actually being hurt? The fact that you don't like it, or the fact that your feelings are hurt by the law, is not good enough. The judge in this case disposes of this question relatively easily. And the judge says, I adhere to my conclusion from an earlier hearing that plaintiffs have standing to sue because it's clear from the face of the statute that plaintiffs are excluded from an exemption granted to others. The plaintiffs in this case were people who worked for organizations that were not religious, namely Freedom from Religion. And they said, hold on a second, if we're granted parsonage, if we're granted housing as part of our benefits package, which I guess they are, we can't go get 107. We can't go get the parsonage benefit. That's discriminatory. Just because we're not a religious organization doesn't mean that it's constitutional to deny us this sort of benefit. And the defendants, the people who were supporting the parsonage exemption, said, hold on a second, you never actually applied under Section 107. You were never actually denied. And the court said, yeah, but it's obvious that they were not clergy people. It's obvious that they were not defined under Section 107, and so therefore we think that the fact that 107 exists, allowing parsonage benefits for ministers, and not allowing parsonage benefits for these people who work for the Freedom from Religion Foundation, that's enough for us to allow standing. So with that in mind, we can move on to the substance of the case. And this is kind of an overview, and then I'm going to go into the nitty-gritty of the details. The judge concludes that Section 107.2, the one that allowed the religious organization to pay rent for clergy people and not have it count as income tax, violates the Establishment Clause under the holding of a case called Texas Monthly Incorporated versus Bullock, which is a U.S. Supreme Court case, and we will look at that case in a few minutes, because the exemption provides a benefit to religious persons and to no one else, even though doing so is not necessary to alleviate a special burden on religious exercise. The plaintiffs had made another equal protection argument, which the court said was unnecessary to deal with because we're finding it unconstitutional anyway. So there are two elements you can see of this one paragraph. First of all, Section 107 provides a benefit to religious people that other people don't get. A benefit to religious clergy that other people don't get. And second of all, this benefit is not necessary to allow them free exercise of religion. As we'll see a little bit later on, it's also required that by the same Constitution that requires a separation of church and state, that says that Congress shall make no law regarding the establishment of religion, it also says that Congress can't prohibit the free exercise thereof. So if there was something that would cause a tremendous burden on the free exercise of religion, it could be allowed or it could be struck down based on that clause alone. So the court's saying two things. Number one, this only gives an exemption to religious people, and number two, Section 107 is not necessary to ensure the free exercise of religion, and therefore Section 107 has to be struck down. So first let's look at the reasoning of the judge. When you're talking about freedom from religion cases, when you're talking about establishment cases, remember the first clause of the entire First Amendment says that Congress shall make no law regarding the establishment of religion. And the bulwark case, the seminal case in that area, is the case of Lemon versus Kurtzman. Under Lemon, the government action violates the Establishment Clause if it has no secular purpose, if its primary effect advances or inhibits religion, or it fosters an excessive entanglement with religion. That's the overall standard. Now that standard was applied in a similar manner in the case that we saw a couple of moments ago, called Texas Monthly Incorporated versus Bullock. In that case, the statute at issue exempted from state sales tax periodicals that are published or distributed by a religious faith that consist wholly of writings promulgating the teaching of that faith that consist wholly of writings sacred to a religious faith. In other words, there was this Texas law, and this Texas law said when you're talking about sales tax, in terms of books, certain religious books that are based on the faith, books, things like Bibles, things that are published and distributed based on religious faith, are exempt from certain types of taxes. And the U.S. Supreme Court struck that down. It was a little bit of a messy decision. There was no actual majority. There were just a bunch of little opinions. But the plurality of opinion, in other words, the one that garnered the signatures of the most justices on the U.S. Supreme Court, emphasized that the exemption provided a benefit to religious publications only, without a corresponding showing that the exemption was necessary to alleviate a significant burden on free exercise. If you're going to make a rule that only justifies or that only benefits religious people or religious organizations, and it's not necessary to allow their free exercise, then it has to be struck down. Now, I think it's pretty clear from the outset that Parsonage, that we looked at in terms of Section 107, only applies to religious organizations. Getting back to 107, it's literally said in the case of minister of the gospel, which again sounds pretty religious to me. But what about the other argument? The argument that there is a burden placed. If the parsonages are not going to be tax exempt, there's going to be an extra burden on clergy members. Well, the court says as follows. Although it's undoubtedly true that taxes impose a burden on ministers, the same is true for all taxpayers. Defendant don't identify any reason why a requirement on ministers to pay taxes on a housing allowance is more burdensome for them than for many millions of others who must pay taxes on income used for housing expenses. So essentially what the court says, yes, it's a burden on clergy members to pay income tax on their parsonage benefits, but other people who get housing as part of their income also have the same problems. So far, it seems pretty cut and dried, right? Clearly Section 107 benefits religious people and doesn't really seem to impose a burden on religion any more so than it would anybody else in a similar situation. So with that essentially the basis for the court decision. But now let's take a look at the opposite. Now let's take a look at the defendant's contentions, the clergy members' contentions, the contentions why parsonage exemption should be allowed, and what the court did to try to counter those arguments. And to do that, to make this decision, the district court judge had to go through a whole bunch of precedents that actually did allow certain exemptions for religious organizations and had to explain why they were different. So let's take a look at some of those. First of all, as you can see, the judge acknowledges that the defendant cites several cases in which courts have found that similar exemptions for certain religious persons from paying taxes to Social Security are permissible accommodations of religion. One example, which is discussed over here, is the exemption for certain religious groups from paying Social Security. Essentially, the courts have ruled that it's reasonable to accommodate people who have cultural rules that require them to take care of their elderly and so therefore do not need Social Security, that they can be exempt from the entire Social Security system. So why is that different from this case, which is also benefiting a particular religion? Well, the court explains that that's not really a preference. The court says that first of all, it's limited to people who have a religious objection to receiving public insurance. And also, even probably more importantly, there's no preferential treatment to religious persons because it's not well, yes, it's true they're not going to be paying Social Security tax, but they're also not going to be getting Social Security. So overall, they're essentially breaking even. I guess you could argue whether Social Security in the long run is a benefit or a burden, but the fact is you're not really preferentially treating these organizations because whereas they're not going to have to pay Social Security tax, they're also not going to actually get Social Security from the government. So they're not being necessarily preferentially treated. Also, certain religious groups have gotten exemptions from discrimination rules. You can see in the Amos case, also a U.S. Supreme Court case, the court upheld a religious exemption in an anti-discrimination law that otherwise would have required religious groups to violate their own religious beliefs, such as requiring Catholic churches to ordain women as priests. So certain types of discrimination rules, gender discrimination rules, can be waived for religious organizations, if required by their religious beliefs. But again, the court says, well, that's different because in that case, applying the rule would impose a substantial burden on the religion. In this case, the entire court's point is that there's no specific burden that's going to be imposed on clergy by not allowing the tax-exempt parsonages that isn't already applicable to other people anyway. Also, the court acknowledges and looks at the case of Cutter versus Wilkinson, which said that in which the U.S. Supreme Court said that a law requiring administrators to provide certain religious accommodations to people in state institutions was justified. So again, the court said, well, how do we differentiate? In that case, the court seemed to think it was all right for religions to be benefited by specific rules. But again, the court said in that case the exemption was necessary to avoid imposing burdens on the religious people. So in both situations, the accommodations are best described not as singling out religious persons for more favorable treatment, but as an attempt to prevent inequality caused by government-imposed burdens. We'll give you exemptions to anti-discrimination rules, and we will give you special accommodations for your religion in state institutions, because otherwise there would be a massive burden on your ability to freely exercise your religion. Whereas again, in our case, with the parsonage, you don't need parsonage to practice your religion. Next, the Wisconsin Federal Court takes on what might have been the heaviest case in the arsenal of the defendant, and that is Walls versus the Tax Commissioner of New York, also a relatively famous case. In that case, the property tax exemption for churches and religious properties, which still exists, of course, to this day, was challenged, and the U.S. Supreme Court upheld it, saying that a grant of a tax exemption was not sponsorship of the organization, since the government did not actually transfer part of its revenue to the churches, but simply abstained from demanding that the church support the state. In other words, the Supreme Court said it's okay if the government says religious properties are exempt from property taxation. Now that seems to be pretty close to our case. In our case, what's Section 107 saying? That religious or parsonage applied to by religious organizations to religious clergy are exempt. It seems pretty close to walls. So how is our court going to distinguish that? Well, this is how they do so. First of all, they acknowledge, of course, that the defendants relied on walls. And the court says the obvious distinction between walls in this case is that the statute in walls was not a tax exemption benefiting religious persons only, but a wide variety of non-profit endeavors. In fact, as you may know if you know a little bit about property tax, churches and religious organizations are not the only people who are exempt from property tax benefits, but it's also certain types of non-profit organizations, maybe museums, that are non-profit, things that are educational, things that are charitable, things that are, get benefit of tax-exempt status from the government. So that's how the court distinguishes, saying whereas Section 107 specifically applies to religious organizations and religious clergy, the property tax exemption does give benefits to religious organizations, but it also gives benefits to secular organizations. So we can't use walls as a precedent to allow Section 107 to stand. Finally, the defendants made an argument that I have to tell you I found pretty amusing. I actually found pretty clever. And that is they argued that Section 107 doesn't only apply to religious people, because theoretically the word minister of the gospel could also include people who are non-religious. In fact, the defendants argued it could also apply theoretically to an atheist minister. If you were, for example, a minister who went out and preached atheism, you theoretically could also get the Section 107 benefit, and so therefore Section 107 doesn't specifically benefit religious people. And the court toys with this argument for a little while, and eventually just says, essentially, I'm not convinced. The court's, I think the court plainly was at least a little impressed by the audacity of this argument, but this is how the court deals with it. The court says, defendants argued, in the context of addressing plaintiff standing, that it's conceivable that an atheist could qualify as minister of the gospel under Section 107 and therefore also get the exemption. So first of all, the court says, I'm not aware of any decision in which a majority of the Supreme Court considered whether the Establishment Clause should be allowed just because it also is granted to atheists but excludes secular groups. In other words, excludes groups that have nothing to do with religion. Obviously, Section 107 does not apply to organizations that have nothing to do with religion. So even if it also could theoretically apply to an atheist minister of the gospel, whatever exactly that would mean, that still wouldn't necessarily save it. And the court interestingly says that the advancement of religion would also theoretically apply if it applies to atheists, almost kind of saying, well, in this context, atheism would almost be a form of religion. Thus, if atheism were included under the umbrella of religion, it would still advance religion over secular interests, even if the provisions did apply to atheists, because secular taxpayers would still be excluded from this benefit. Essentially, the court is saying, even if atheists are allowed under Section 107, that would only be necessarily because you consider them religious, or a type of religion, and therefore it would advance religion anyway. And so then the court kind of said, well, and I still I can't accept this argument. Regardless, to the extent the defendants mean to argue that Section 107 is constitutional because of the possibility that an atheist could qualify as a minister, I disagree. No reasonable construction, according to the court, would include atheists. The court rejected as facially implausible that atheistic literature could be included as part of religious documentation. So the case actually was discussed in the Texas Monthly. The issue was discussed in the Texas Monthly case as well. And then the court notes that the defendants cite no evidence that an atheist minister exists, a term that many might view as an oxymoron, let alone an atheist that satisfies the IRS criteria for minister of the gospel, and therefore the court rejects this argument. And then at the end, the judge does something even more interesting. The judge says, I'm striking down 107 over here, but I'll give you a little bit of advice to the IRS. And that is that parsonage benefits are okay. You just can't restrict them specifically to religious people. Look and listen to what the court says. Although I conclude that 107 violates the Establishment Clause and must be enjoined, this doesn't mean the government is powerless to enact tax exemptions that benefit religion. As long as they just provide incidental benefits to religion, that's okay. So if Congress believes that there are important secular reasons for granting the exemption in 107, then it's free to rewrite the provision in accordance with the principles down in Texas Monthly and Walls so that it includes ministers as part of a larger group of beneficiaries. In other words, the court is saying, you want to keep, if you, the IRS, you want to keep the exemption for clergy members, that's okay. Just don't restrict it to religious people. Maybe if 107 were rewritten to say something like, all people who are provided housing as part of their benefits and who work for non-profit organizations or educational organizations, charitable organizations, or religious organizations can all have the benefit, well, then this judge wouldn't necessarily have any problem with it, and the judge would concede that it would be constitutional. However, as it stands now, according to the Western District of Wisconsin, 107.2 is unconstitutional. And again, if you ask me, will this be upheld by the Seventh Circuit? Will this be adopted by other courts? If it's accepted by the U.S. Supreme Court for certiorari, will the Supreme Court adopt this holding? I don't know. It seems fairly persuasive. Certainly arguments could be made the other way. So I don't know what will happen eventually, but I thought this was a very interesting case that went through all the arguments and made a fairly comprehensive and fairly persuasive decision on the issue of parsonage. So thank you very much for listening. And hopefully I've given you something to think about with regard to the First Amendment and taxation and tax benefits. For the National Paralegal College Faculty's Legal Analysis of the News, this is Stephen Haas. Have a wonderful day, everybody.